So this is the story about how the 7th Circuit Court of Appeals absolutely destroys a home design company's floor plan-based copyright trolling scheme, which had them file over 100 copyright cases in federal court and probably resulted in thousands of victims paying some kind of license fee or settlement. This is DesignBasics and Carmichael and Dame Designs versus Signature Construction. Buckle up, this one's going to be good. The court does a really good job explaining all of the details in the minimum number of words possible, so I'm just going to read through the opinion and illustrate it with some examples from the court case. Copyright law strikes a practical balance between the intellectual property rights of authors and the public interest in preserving the free flow of ideas and information and encouraging creative expression, all in the furtherance of the constitutional purpose to promote the progress of science and useful arts. Copyright trolls, opportunistic holders of registered copyrights whose business models center on litigation rather than creative expression, disrupt this balance by inhibiting future creativity with negligible societal benefit. Quote, like the proverbial troll under the bridge, these firms try to extract rents from market participants who must choose between the cost of settlement and the costs and risks of litigation. And that's from a previous DesignBasics case, which you're going to hear about more, called DesignBasics v. Lexington Homes. Plaintiff DesignBasics is a copyright troll. The firm holds registered copyrights in thousands of floor plans for suburban, single-family tract homes, like these, for example. Its employees trawl the internet in search of targets for strategic infringement suits of questionable merit. The goal is to secure, quote, prompt settlements with defendants who would prefer to pay modest or nuisance settlements rather than be tied up in expensive litigation. As we have explained in the Lexington Homes case, this business strategy is far removed from the goals of the Constitution's intellectual property clause. Instead, it amounts to an intellectual property shakedown. This appeal involves yet another DesignBasics infringement action, one of more than 100 such suits in the last decade or so. When DesignBasics was last before this court in Lexington Homes, we were guided by two well-established copyright doctrines, Faire and merger, that constrain the ability of infringement plaintiffs to claim expansive intellectual property rights in a manner that impedes future creativity. Applying these doctrines, we held that DesignBasics copyright in its floor plans is thin. The designs consist mainly of unprotectable stock elements, a few bedrooms, a kitchen, a great room, etc., and much of their content is dictated by functional considerations and existing design conventions for affordable suburban single-family homes. When the copyright in an architectural work is thin, only a strikingly similar work will give rise to a possible infringement claim. Applying this standard, we held that no reasonable jury could find for DesignBasics and affirmed a summary judgment against it. This latest appeal meets the same fate. DesignBasics sued Signature Construction and related companies, accusing them of copying 10 of its registered floor plans for suburban single-family homes. The district court entered summary judgment for the defendants based largely on the reasoning of Lexington Homes. DesignBasics asks us to overrule the Lexington Homes case. We decline to do so. And we take this opportunity to restate and clarify the elements of a prima facie case of infringement, both as a general matter and more particularly in cases involving works of this type in which copyright protection is thin. For this category of claims, only extremely close copying is actionable as unlawful infringement. Put more precisely, this type of claim may move forward only if plaintiff's copyrighted design and the allegedly infringing design are virtually identical. That standard is not satisfied here, so we affirm. We described DesignBasics' business strategy in Lexington Homes. A brief summary will suffice for present purposes. DesignBasics holds registered copyrights in thousands of floor plans for suburban single-family homes. The plans are not technical construction drawings, rather they are basic schematic designs, largely conceptual in nature, and depict layouts for 1- and 2-story single-family homes that include the typical rooms, a kitchen, dining area, great room, bedrooms, bathrooms, laundry area, garage stairs, and assorted closets. More than a decade ago, Patrick Carmichael and Miles Sherman bought DesignBasics as an investment opportunity. Since then, litigation proceeds have become a principal stream of revenue for the firm. Indeed, DesignBasics incentivizes its employees to search the internet for litigation targets by paying a finder's fee, a percentage of net recovery, if they locate a prospective infringement model. This is the core of the firm's business model. The firm maintains an easily accessible website displaying 2,847 floor plans. It also regularly sends mass mailings of its designs to members of the National Association of Home Builders. Over the years, the firm has sent millions of publications containing its floor plans to home builders. When it initiates litigation, it hopes, indeed it expects, to find these designs in the defendant's files. This case had its genesis in that business model. In 2014, Paul Forsman, Director of Business Development at DesignBasics, emailed Carmichael with the subject line, "A gift for you." Forsman told Carmichael that by using the Internet Archive's Wayback Machine, he discovered that a firm called Signature Homes may have copied some of DesignBasics' home designs. Carmichael was initially confused because DesignBasics was already asserting infringement claims against a firm by that name, but Forsman clarified that this Signature Homes, based in Illinois, was a different company. Pleased with Foreman's discovery, Carmichael wrote back, "Wow, a very nice gift, my friend." This infringement suit followed. In 2016, DesignBasics sued Signature Construction and related companies alleging that they infringed 10 of its floor plans. During discovery, DesignBasics learned that Signature's files contained photocopies of 4 of its plans: Ainsley, Shawnee, Columbus, and Kempton Court. The photocopies were found in Signature's files for homes labeled Carlisle, Lot 119 Lake Falls, Lot 63 Summer Place, and Lot 309 Stonegate, respectively. The photocopy of DesignBasics' 2461 Shawnee floor plan had red markings on it, indicating modifications to the plan. John Tanner, a draftsman at Signature, testified that he received the marked-up image from Steve Mead, a Signature partner, and understood that the markings were modifications that Mead wanted him to make. At the end of lengthy discovery, Signature moved for summary judgment, relying heavily on our ruling against DesignBasics in Lexington Homes. As we explained in that opinion, under the Faire and merger doctrines, DesignBasics copyright protection in its floor plans is thin, and therefore only a strikingly similar plan would give rise to an infringement claim. Using this standard, we held that no reasonable jury could find infringement. Along the way to this conclusion, we noted that DesignBasics had not submitted expert testimony to support its claim, relying instead on a conclusory declaration from one of its draftsmen. DesignBasics tried to avoid that same criticism here by submitting an affidavit from a third-party expert in opposition to Signature's summary judgment motion. The witness, Matthew McNicholas, is an architect and has served as an outside expert for DesignBasics in at least 13 lawsuits. McNicholas asserted that Signature unquestionably infringed DesignBasics' home plans. To support that opinion, McNicholas produced a 103-page report. The first 30 pages covered his qualifications and explain his general views on architectural copyright law. Pages 32 to 85 are descriptions of the 10 copyrighted floor plans at issue in this case. This section of his report contains narrative descriptions of the features of each DesignBasics floor plan, but the descriptions are remarkably similar to one another. Indeed, some parts are almost word-for-word identical. A few examples will illustrate. For the DesignBasics floor plan called the Linden, McNicholas wrote, "The idea behind the plan of the Linden focuses on creating a home for entertaining guests, and whose spaces are flexible enough to meet the needs of a broad range of potential homeowners. One of the features he analyzed was the front door. From the perspective of a guest, the sheltered front door is a welcome area, not just with the covered stoop, but also composed with walls to either side of the entry, which shelter against wind and driving rain. This consideration for waiting guests reinforces the entertainment value of this design decision." His description of the floor plan called the Manning is similarly generic. The concept driving the plan of the Manning centers around creating a home focused on entertainment, but with enough flexibility to evolve into multiple solutions as the homeowner needs while maximizing privacy. Again, McNicholas described the front door. From the perspective of a guest, the sheltered front door is a welcome area, not just with the covered stoop, but also arranged with the long wall of the living room as a shelter against driving wind and rain while waiting for the door to open. This consideration for waiting guests reinforces the entertainment value of this design decision. His analysis of the Patterson is likewise almost identical. The idea behind the plan of the Patterson focuses on creating a home for entertaining guests and whose spaces are flexible enough to meet the needs of a broad range of potential homeowners. Regarding the front door, McNicholas wrote, "From the perspective of a guest, the sheltered front door is not just a welcome area, but with walls to either side of the entry which shelter against wind and driving rain, it is a considerate space. Further, the side light at the door allows for transparency between the interior and exterior, and this thoughtfulness for waiting guests reinforces the entertainment value of this design decision." In short, the McNicholas report purports to separately analyze the distinguishing features of each of the copyrighted plans at issue here, but the descriptions are so ordinary and interchangeable as to be virtually meaningless. The McNicholas report ends with a visual section containing side-by-side comparisons of the signature floor plans and the DesignBasics plans they are alleged to infringe. As the district judge described this section of the report, the expert employed extensive color filling to depict parallel rooms in the copyrighted and accused plans in matching colors in an effort to make the plans seem more similar. The judge rejected this technique as an attempt to manipulate and enhance the appearance of similarity. To control for this problem, the judge extracted the line drawings from the plans without the color-filling enhancements and confined his analysis accordingly. Comparing the unenhanced drawings, the judge determined as a matter of law that no unlawful copying occurred. He noted multiple categories of dissimilarity between the copyrighted and accused plans. Room dimensions are different, the judge writes. Some plans have more rooms than the plans they are alleged to infringe. Ceilings are of different heights or of different styles, cathedral versus flat versus tray. Exterior dimensions are different. Bathrooms are in different locations. Sinks, tubs, toilets, and showers are in different locations within bathrooms. Garages are of different sizes and/or are in different orientations to the rest of the house. Based on these observations and applying Lexington Holmes, the judge had no difficulty concluding that Signature's plans are dissimilar enough to avoid infringing the thin copyright in DesignBasics plans. The judge entered final judgment for Signature, and DesignBasics appealed. Copyright and patents, the Constitution says, are to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And the judge cites to the recent Google v. Oracle decision. To that end, the Copyright Act establishes the prerequisites for copyright and sets limits on its scope. Congress weighs the advantages and disadvantages of copyright protection and establishes its boundaries and conditions, the existence of exceptions and exemptions, all by exercising its own constitutional power to write a copyright statute. The basic prerequisites are these. Copyright protection subsists in original works of authorship fixed in any tangible medium of expression. Originality is a constitutional requirement, arising by implication from the Constitution's reference to authors and writings, citing to the Feist Publications versus Rural Telecom case from 1991, the telephone book case. The threshold for originality is low. Original, as the term is used in copyright, means only that the work was independently created by the author, as opposed to copied from others, and that it possesses at least some minimal degree of creativity. The Act lists categories of works that qualify for copyright protection, including literary works, musical works, dramatic works, pictorial works, graphic and sculptural works, among others. Architectural plans and technical drawings are included in the statutory definition of pictorial, graphic, and sculptural works, and can be copyrighted in this category. Until 1990, however, architectural works were not included in the definitions section as a standalone category of protected works. That left some uncertainty about the status of constructed designs, i.e. the buildings themselves, among other complexities in this corner of copyrighted works. In 1990, Congress amended the Act to create a separate category of architectural works in the definitions list, implementing our nation's obligations under the Berne Convention for the protection of literary and artistic works. The 1990 legislation added the following definition for the new statutory term architectural work. An architectural work is the design of a building as embodied in any tangible medium of expression, including a building, architectural plans, or drawings. The work includes the overall form as well as the arrangement and composition of spaces and elements in the design, but does not include individual standard features. Importantly, the Act limits the scope of copyright protection, even for works that the definitional provisions might otherwise include. One prominent limitation captures the traditional copyright principle known as the idea-expression dichotomy, the line that separates copyrightable expression from non-copyrightable ideas and facts. Section 102B codifies this principle. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. The Act creates a cause of action for infringement and provides as a general matter that anyone who violates any of the exclusive statutory rights of the copyright owner is an infringer. This generalization doesn't shed much light on what it takes to prove a claim, but the courts have developed and explained the plaintiff's burden of proof. The doctrine begins with this statement from the Supreme Court. To establish infringement, two elements must be proven. 1, ownership of a valid copyright, and 2, copying of constituent elements of the work that are original. This concise formulation obscures a good deal of complexity beneath the surface, but it provides a basic framework for the claim. The first element, ownership of a valid copyright, is not contested here. DesignBasics registered its floor plans with the U.S. Copyright Office, and Signature does not dispute its ownership or the validity of the copyrights. We therefore assume, as we did in Lexington Homes, that DesignBasics owns the plans and that the plans are entitled to some copyright protection, i.e., they were created independently and possess a modicum of creativity to satisfy the minimal originality requirement. This litigation turns on the second element, as many infringement cases do. At this step of the general framework, the plaintiff must prove that the defendant copied constituent elements of the copyrighted work that are original. This element actually encompasses two distinct questions, although our case law hasn't always neatly separated them. The first question is whether, as a factual matter, the defendant copied the plaintiff's protected work, as opposed to independently creating a similar work. The second question is whether the copying went so far as to constitute an improper appropriation. The Ninth Circuit refers to these distinct subsidiary elements as copying and unlawful appropriation. The Second Circuit uses the terms copying and wrongful copying. Whatever the nomenclature, the point is to capture the important differences between the two. In all infringement cases, the plaintiff must prove, as a factual matter, that the defendant actually copied his work. Proof of copying by the defendant is necessary because independent creation is a complete defense to copyright infringement. For no matter how similar the plaintiff's and defendant's works are, if the defendant created his independently without knowledge of or exposure to the plaintiff's work, the defendant is not liable for infringement. This actually has happened before. I believe the story is of the Dennis the Menace characters. There was an American man who created the Dennis the Menace character in comics that many Americans grew up with. And there was, at the exact same time, a UK man, a United Kingdom citizen, who created Dennis the Menace over there. Neither knew that they were creating two characters with the exact same name, and the two characters actually, they did have things that were the same and things that were different, and I believe there was a copyright claim between them, and the courts determined that because they were created entirely independently, there was no copyright infringement. And you can read about it by doing a search for Dennis the Menace copyright. Importantly, proof of actual copying is necessary, but not sufficient to establish liability for infringement. Not all copying is copyright infringement, so the plaintiff must also prove that the defendant's copying was wrongful, i.e. that the defendant took enough of his protected expression, as opposed to unprotectable ideas, concepts, facts, etc., to constitute unlawful appropriation of his expressive work. The first of these subsidiary elements, let's call it actual copying or copying in fact, can be proved either directly or indirectly. Direct evidence is rare, so many cases turn on inferences to be drawn from circumstantial evidence. A circumstantial case of actual copying requires 1. Evidence that the defendant had access to the plaintiff's copyrighted work, enough to support a reasonable inference that the defendant had an opportunity to copy, and 2. Evidence of a substantial similarity between the plaintiff's work and the defendant's work, enough to support a reasonable inference that copying in fact occurred. I usually summarize these as calling it access and substantial similarity, which are the basic tenets of copyright infringement. We have acknowledged the possibility that an accused work may bear such an uncanny resemblance to a copyrighted work that copying is the only plausible explanation for similarity. In such a case, further proof of access may not be required, but the exception is rare and reserved for unusual cases. Ordinarily, to prove a circumstantial case of copyright infringement, the plaintiff must separately prove both access and substantial similarity. This is the strikingly similar standard. If the copyright work and the infringing work are strikingly similar, then access usually does not have to be proven. Confusion sometimes arises because the test for unlawful appropriation, a distinct inquiry, also looks for substantial similarity between the defendant's work and the plaintiff's work. As the Second Circuit explained, a close similarity between two works is often relevant to proving both actual copying and wrongful copying. Accordingly, the cases often use the same term, substantial similarity, to describe both the degree of similarity relevant to proof of copying and the degree of similarity necessary to establish unlawful appropriation. So the same test is used for both parts of the analysis. Therefore, it gets a little bit confusing. The court's going to try and clarify. But the term means different things in those two contexts. The difference hinges on the distinction between the protected and unprotected elements in the plaintiff's work. When used as a test for actual copying in a circumstantial case, the requirement of substantial similarity is not limited to the protected elements of the plaintiff's work. Similarities that relate to either the protected or unprotected elements of the plaintiff's work may be probative of actual copying. So this is the first element on whether or not copying occurred before we get to whether or not wrongful copying occurred. The inquiry simply looks for the kind and degree of similarity that one would not expect to arise if the two works had been created independently. Put somewhat differently, in a circumstantial case, the plaintiff has the burden to show that the two works are so similar that copying is a better explanation for the similarities than pure coincidence. But similarity that relates to unprotected elements is probative only of actual copying, not of wrongful copying. Wrongful copying, unlawful appropriation, requires substantial similarity between the defendant's work and protected elements in the plaintiff's copyrighted work. When an original work contains many unprotected elements, a close similarity between it and a copy may prove only copying, not wrongful copying. To preserve the distinction between these two concepts, we will follow the Second Circuit's lead and use the term probative similarity to refer to the degree of similarity necessary to support an inference of actual copying, and the term substantial similarity to refer to the test for wrongful copying or unlawful appropriation. So, probative similarity is whether or not copying in fact occurred. Just any copying, we don't care whether it's legal or illegal, just trying to establish that copying occurred. And then substantial similarity will be the test for wrongful copying or unlawful appropriation, at least in the Seventh Circuit and the Second Circuit. Our circuit, like most others, uses the ordinary observer test for unlawful appropriation. Whether the accused work is so similar to the plaintiff's work that an ordinary, reasonable person would conclude that the defendant unlawfully appropriated the plaintiff's protectable expression by taking material of substance and value. But in Lexington Holmes, we explained at length that under the Faire and merger doctrines, so for you audio people, Faire is a French phrase, scenes à faire, F-A-I-R-E, like scenes to do, which is sort of a term of art that will mean usual scenes in a story. We're going to be talking about whether or not two people on a bench in a park is copyrightable, or whether it's only copyrightable when you add more to it. And then, even then, only the adding of more, only that more would be copyrightable. So under the Faire and merger doctrines, DesignBasics holds only a thin copyright in its floor plans, or thin copyright protection. Just a brief recap is needed here. Standard elements in any genre, called Faire in copyright law, get no copyright protection. Faire are so rudimentary, commonplace, standard, or unavoidable scenes that they do not serve to distinguish one work within a class of works from another. If standard elements received copyright protection, then the creation of a single work in any genre would prevent others from contributing to that genre because the copyright owner would have exclusive rights in all of the genre's basic elements. We explained in Lexington Holmes that DesignBasics floor plans largely consist of Faire. Every plan has a kitchen, a great room or living room, a dining room, bedrooms, bathrooms, and so forth. The arrangements of the rooms are also largely Faire. The kitchen is always close to the dining room. The bedrooms will usually be clumped together and near a bathroom. The door from the garage into the house usually leads to the kitchen rather than to the great room or living room. What accounts for these familiar arrangements? Convention in this genre, which brings this particular type of architectural work within the Faire doctrine. But the arrangements are also dictated by functionality. The kitchen is near the dining room so that food can easily be moved between the two rooms. The bedrooms aren't near the front hall because guests don't venture into the bedrooms. The functionality of the room arrangements is where the doctrine of merger comes in. Merger arises from Section 102B, which, as we've explained, codifies the idea-expression dichotomy and specifies that copyright never extends to an idea, procedure, principle, or concept. Copyright protects only expression. Patent law is the proper instrument for protecting functionality. The merger doctrine prevents the use of copyright to protect an idea or procedure. If an idea or procedure can be expressed in only a few ways, it is easy to copyright every form in which the idea can be expressed, indirectly protecting the idea itself. So the merger doctrine means that we don't want copyright protection to extend to the idea. So if that idea only has a limited number of expressions, the merger doctrine means that expression cannot be copyrighted either until, again, something more is added, something that is copyright protectable and goes beyond the basic idea. So the idea that a kitchen would be next to a dining room can only be expressed so many ways on a floor plan. You write a box with a kitchen and a box with a dining room, and how else would you be able to express that? So that can't be copyrighted because you could never ever express the idea of a kitchen and a dining room being next to one another without drawing boxes next to one another labeled kitchen and dining room. To guard against this kind of overprotection, when an idea can be expressed only in limited ways, courts say that the expression merges into the idea and cannot receive copyright protection. For example, the forms used to implement a particular method of accounting are an expression of the accounting method and cannot be copyrighted. So if you have a balance sheet and you have accounts receivable and accounts payable, well, you can't copyright the idea that of having a balance sheet with accounts receivable and accounts payable and et cetera, because then nobody could use that accounting method without paying you a license fee for your copyright. There is no other way to show that accounting method without putting it in that particular format. The same is true for the rules of a sweepstakes competition. Because there are a limited number of ways to explain the rules, the expression of the rules receives little, if any, copyright protection. Merger also applies to the DesignBasics home plans. The functional requirements of living spaces dictate that particular rooms are placed close together, and the general concept of the affordable multi-purpose suburban single-family home also contributes to the design. This isn't to say that there is only one way to arrange the rooms in this home design genre, but there are only a limited number of possible floor plans, and by creating more than 2,800 of these plans, DesignBasics has attempted to occupy the entire field. We wondered in Lexington Homes if there is any blueprint for a single-family home anywhere in the country that DesignBasics could not match to one of its own designs. If DesignBasics held any more than thin copyright protection in its floor plans, it would own nearly the entire field of suburban single-family home design. The McNicholas report reinforces our holding in Lexington Homes that the copyright in the DesignBasics floor plans is thin. Although McNicholas set out to demonstrate the unique nature of the 10 floor plans at issue here, his report demonstrates just the opposite. As we've explained, the report describes each floor plan in generic and often nearly identical language. The report shows that each floor plan uses the same design features to accomplish the same ends. Accordingly, although DesignBasics asks us to revisit our decision in Lexington Homes, we see no reason to do so. DesignBasics urges us to instead adopt the First Circuit Court of Appeals approach in TPEG versus Vermont Timber Works, which looked to similarities in the overall form of the buildings to assess architectural copyright infringement. DesignBasics is wrong to suggest that our approach differs from the First Circuit. To the contrary, we reiterate our conclusion that DesignBasics holds only thin copyright in its floor plans, and in this particular architectural genre in which copyright protection is thin, proving unlawful appropriation takes more than a substantial similarity between the plaintiff's work and the defendant's work. Instead, only a virtually identical plan infringes the plaintiff's copyrighted plan. We can make short work of applying these principles to this record. Except for the 2461 Shawnee plan, DesignBasics has no direct evidence of actual copying. For the remaining 9 plans, it must rely on circumstantial proof of actual copying, which requires evidence of both access and probative similarity. We can safely skip the issue of access. The district judge aptly observed that the signature plans are dissimilar in material respects from the plans they are alleged to have infringed. They have different room dimensions, ceiling heights and styles, and exterior dimensions. Some have a different number of rooms, and the garages are sometimes placed at different angles to the homes. These differences are enough as a matter of law to preclude an inference of actual copying. For the same reason, even if we assume that actual copying occurred in the case of the Shawnee floor plan, no reasonable jury could find unlawful appropriation. Signature's Lot 119 Lake Falls floor plan is not virtually identical to the 2461 Shawnee. Though both designs depict a one-story ranch with a kitchen, breakfast room, great room, dining room, 3 bedrooms, and 2 bathrooms in the same general locations, the signature plan is different from the 2461 Shawnee in some notable ways. It has greater square footage, the room dimensions are subtly different, the ceilings have different heights, and the 2 homes have different aspect ratios. The Shawnee has a 2-car garage and its walls are parallel to the home, where the Lake Falls floor plan features a 3-car garage placed at an angle to the rest of the home. Although most of the rooms are located in the same relative positions, some are not. The Shawnee floor plan places a bathroom where the Lake Falls plan has a walk-in closet. In a field unconstrained by convention and functionality, the similarity of the overall layouts of the 2 floor plans would be noticeable, but suburban single-family housing is a field with many standard elements and limited possibilities for creativity, so the Lake Falls plan must be virtually identical to the Shawnee to infringe DesignBasics' thin copyright. Under this standard, Signature's plan is non-infringing as a matter of law. Finally, we note for completeness that we find no flaw in the district judge's conclusion that signatures plans are dissimilar enough to preclude liability even under ordinary substantial similarity analysis. As we explained when discussing probative similarity, each signature plan features different room dimensions, ceiling styles and heights, and exterior dimensions than the DesignBasics plan it is alleged to have infringed. The number and placement of rooms is sometimes different, as is the size and the location of the garage. Accordingly, the judge correctly concluded that the signature plans are non-infringing under conventional substantial similarity analysis. The plans are certainly not virtually identical to the DesignBasics plans they are alleged to infringe. Summary judgment for signature was proper. And the icing on the cake of this decision is that the judge in the lower court, the Central District of Illinois Urbana Division, had ordered, after a lengthy analysis, that DesignBasics will have to pay an attorney's fee award of at least $193,875.50, and that's before the appeal, which would likely add another 5 to 6 figures onto that amount. So I'm guessing we have about $250,000 owed to Signature's attorneys, or Signature for having paid their attorneys, maybe even as high as $300,000 by the time you get done with it. And that's the right result. Putting boxes on a floor plan to represent rooms of a house should not create a high barrier for others creating similar floor plans. It should only be copyright protection if someone actually copies your floor plan item for item, directly copies the plan and uses it specifically. Copying someone's floor plan and then making a similar but not strikingly similar or exactly similar floor plan just isn't enough for copyright infringement. Certainly, there could be more to a floor plan that does create some kind of copyright protection. For example, maybe interior design, when you start to say, we're going to feng shui this room and it's going to be designed with these colors and this layout, and we're going to put the TV here, we're going to put some plants over here, we're going to have this very specific architectural lighting over here, and it's going to make this lighting effect, and all of that together probably has more copyright protection than just a basic floor plan. So I find it really interesting that DesignBasics would have gone with this as their business model. I also found a few other really interesting things. If you go to DesignBasics website and you try to right-click on something, as I would try to right-click up here and choose open in new tab so I could have 40 million tabs open, it brings up a copyright notice. 1996 to 2018, all rights reserved, DesignBasics, all home plans, garage plans, plans for other structures, photos, drawings, and images are protected under copyright law. Any unauthorized use is strictly prohibited. Please call us for information about using these images. It's also interesting how much they're charging for these plans. For instance, here's a floor plan called the Linden, and if you wanted a PDF of this plan, it's $1,055, and that's before you get to use it for promotion and yard signs and et cetera, which I'm not even sure what all of that means. If you wanted the single build is $1,000 and add $500 for an unlimited build. If you want different foundation options, it adds a couple $100. So it's interesting that they're charging this much money. I wonder how many companies actually buy floor plans for $1,555, or how many companies would just create their own floor plan, possibly looking at the floor plan on the website here and saying, oh, well, I'm going to make it a little bit different to make it my own. And it seems from the Seventh Circuit Court of Appeals, at least, that DesignBasics doesn't have a copyright on the basic floor plans, and you could make your own floor plan, even being inspired by theirs. That's not individualized legal advice, though, so don't hold me to it. Ask your own attorney if you're going to actually try and make a business out of copying DesignBasics floor plans. The circumstances under which you're copying it will also matter. So I think that's a great copyright case and a opportunity to learn all about the Faire and merger doctrines in copyright law and the protection only for original expression of an idea and not for trying to claim ownership generally of everything within a genre by making simple floor plans and then claiming all of the home designs basically in the world or in the country. So let me know what you think of that one in the comments below. This is a good example of how copyright trolls in general work. They create sort of a minimal copyright that's going to be widely used by others, and then they police the internet for infringement upon that. Photographers can become copyright trolls. And to be clear, I'm not saying most photographers are. I'm saying a photographer can become a copyright troll by posting their images on the internet for sale or for use under certain licenses, and then policing the internet using Google image search and other tools to find people who are using the images without permission. Sometimes they sue everybody, sometimes they look for very specific uses. This doesn't mean that every photographer who posts their image and then sues is a copyright troll. It's when you do it on purpose. Say, create a free images website, freeimages.com or something like that, and it has thousands of images, and then you look for people who didn't read the fine print to realize that the images weren't in fact free. They were maybe free to look at, not necessarily free to copy paste into a meme or something like that. And many times copyright trolls don't take into account these basic tenets of copyright law or fair use. And many of them make a business model off of copyright enforcement. And the distinction really is that a plaintiff who is heavy on copyright enforcement might not be a copyright troll, but when they make it their primary business model, and when they sue for settlements, and when maybe they don't have the copyright protection that they thought that they did, that's where they turn into a copyright troll. And so DesignBasics is a great example of a copyright troll. And we can call them a copyright troll without fear of reprisal because the court has now said they are a copyright troll. So let me know what you think in the comments below of this Seventh Circuit smackdown of a floor plan, a home floor plan copyright troll. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floorplan, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floorplan membership. Thank you very much in April of 2021 to our $50 plus supporters, Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
Your mum sounded better when she done the gobble gobble.